In criminal law, guilt is the state of being responsible for the commission of an offense. Legal guilt is entirely externally defined by the state, or more generally, a court of law. Being guilty of a criminal offense means that one has committed a violation of criminal law, or performed all the elements of the offense set out by a criminal statute. The determination that one has committed that violation is made by an external body and is therefore as definitive as the record-keeping of the body. So the most basic definition is fundamentally circular. A person is guilty of violating a law if a court says so. Philosophically, guilt in criminal law is a reflection of a functioning society and its ability to condemn individuals' actions. It rests fundamentally on a presumption of free will, in which individuals choose actions and are, therefore, subjected to external judgment of the rightness or wrongness of those actions. An adjudication of guilt is more than a factual determination that the defendant pulled a trigger, took a bicycle, or sold heroin. It is a moral judgment that the individual is blameworthy. Our collective conscience does not allow punishment where it cannot impose blame. Our concept of blameworthiness rests on assumptions that are older than the Republic. Man is naturally endowed with these two great faculties, understanding and liberty of will. Historically, our substantive criminal law is based on a theory of punishing the vicious will. It postulates a free agent confronted with a choice between doing right and wrong, and choosing freely to do wrong. See also Cotton, Michael, A Foolish Consistency, Keeping Determinism Out of the Criminal Law, 15b. U. Pub. Int. LJ1 Moral and Legal Definitions. Guilt is the obligation of a person who has violated a moral standard to bear the sanctions imposed by that moral standard. In legal terms, guilt means having been found to have violated a criminal law, though law also raises the issue of defenses, pleas, the mitigation of offenses, and the defeasibility of claims. Les Parrott draws a threefold distinction between objective illegal guilt, which occurs when society's laws have been broken, social guilt, an unwritten law of social expectation, and finally the way personal guilt occurs when someone compromises one's own standards. Remedies. Guilt can sometimes be remedied by punishment, forgiveness, making amends, or acts of reparation or restitution, are an important step in finding freedom from real guilt, or by sincere remorse. Guilt can also be remedied through intellectualization or cognition. Helping other people can also help relieve guilt feelings. Thus, guilty people are often helpful people. Helping, like receiving an external reward, seem to get people feeling better. There are also the so-called Don Juans of achievement, who pay the installments due to the superego not by suffering but by achievements. Since no achievement succeeds in really undoing the unconscious guilt, these persons are compelled to run from one achievement to another. Law does not usually accept the agent's self-punishment, but some ancient codes did. In Athens, the accused could propose their own remedy, which could, in fact, be a reward, while the accuser proposed another, and the jury chose something in between. This forced the accused to effectively bet on his support in the community, as Socrates did when he proposed room and board in the town hall as his fate. He lost and drank hemlock, a poison, as advised by his accuser.